Episode for higher juicy news. We ma ubibia akwaba had the latest hot nkwa era me bremo. Enuti so nya subscribe to channel dia bomodi as obe subscribe. The way I say we click the subscribe button no. Na wabele notification no. We understand video fufuru bi be upload no. When the first person onsa ebeka sa video afi we na like video no. Give us a thumbs up. Na fe shema wo fufuro na wenye bi hwe na wo hu ensem ekoso e wo Ghana memu ha no afe ye hwe ye ensem abeto ye no so yenti sa report ya ababeto dwa sansem mu yenti.
No matter how many noises are made, the law is the law. No matter how many noises are made, the law is the law.
Big one is what happened in court today. So you would know that the Chief Justice has been trying to fight for her position as the Chief Justice of the Republic. There is a current issue in court against her, and that is what the latest detail we have that we are bringing to you. Now, the Chief Justice Gertrude Torkonoo will have to submit herself to the proceedings of the Presidential Committee probing petitions for her removal. This follows a failed attempt by her to injunct the committee from carrying out its duties. In a unanimous decision earlier today, a 5-member panel of the Supreme Court dismissed an application for an interlocutory injunction filed by Justice Torkonoo seeking to suspend her impeachment process. The court, presided over by Acting Chief Justice Paul Bafoboni, ruled that the application lacked merit and could not be granted. Justice Torkonoo had sought to temporarily halt her suspension and the impeachment proceedings pending the final determination of her lawsuit, which challenges the constitutionality of the process. Well, Dennis Poaberi Wedam Esquire was in court himself and followed proceedings very keenly. He's joined us in studio to get an understanding of what exactly transpired in court today. Dennis, good evening. Thank you for joining us.
Thank you, Martin.
First of all, paint a picture for those of us who were not in court. What was the atmosphere? What was the mood like in court when the Chief Justice came in?
Well, I would say that it's a typical court day, except that observations were quite different. Rules had changed because on an ordinary day, as it used to be, you'd either find the Chief Justice coming from the back to join the bench, and because she was the Chief Justice, she usually would be the president or presiding over the panel that are put together to preside over matters. But today was quite different. For the first time, I mean, personally seeing her coming through where you and I would also pass when we are going into the courts. She walked into the courts, went to assume a seat behind the bar. So when you enter the court, there's the bench where the judges sit, and there's the bar where the lawyers sit. Behind the bar is a place where parties, so if you were my party, you would sit behind. And so she was at that part of the Supreme Court. That's to say that, okay, I'm in here as, excuse my word, but an ordinary person. I have my case before you. So, I mean, that's how it looked like. On the side of the Attorney General, Deputy Attorney General, Dr. Justice Remsai was there for the Attorney General's department, together with some state attorneys. On the side of the Chief Justice's lawyers, the plaintiff applicant, led by former Attorney General, Godfred Yeboah, and also with him, he was there with the legal counsel for former President President Akufo Addo, Eko Esuman was also there. Also behind them, we had Vincent Asafo, who were also there to support. So painting a picture, that's how it looked like. On the panel today, if you recall, the last injunction application was heard by a panel of 5, which included the Acting Chief Justice, Justice Paul Bafoboni. You had Justice Amadou Tanko. You had Justice Yoni Kolondi. There was Justice Anthony Kofi, and then Justice Yao Asare. Today, it was almost a repeat panel, except that Justice Yao Asare has been changed, and now we had Justice Richard Ejefrimpong, who replaced. So that was the panel for today's hearing. What it essentially means is that only one person has been changed from that panel that had the previous injunction applications. I mean, the most immediate, the 2 that were dismissed on 4-1 on the voting of decision for 4-1. So that's how the composition, the atmosphere, and representation looked like in court. But before things could even get started, because from the processes that were filed, I mean, the expectation was that the first thing that would be done today was to hear the preliminary legal objection that was raised by the Attorney General, asking the court to strike out the supplementary affidavit that was filed by the Chief Justice. Now, that supplementary affidavit, I mean, it's been widely reported out there. It is in that document that was contained the allegations of torture, allegations of search, allegations of
denial of carrying mobile
denial of
devices.
carrying mobile laptop and all that. So the Attorney General's preliminary objection or legal objection was to the effect that these were matters that occurred before the committee. So to that extent, they are supposed to be protected under Article 1468. Now, Article 1468 of the 1992 Constitution talks about the fact that proceedings for the removal of a Chief Justice or a Justice of the Superior Court must be in camera. That has received judicial blessing in a number of cases. So the argument was simple, that do not allow this to come on record, else you'll be exposing what is supposed to be in camera. So that was supposed to be the first thing. However, before that could even be heard, there was, I mean, an objection by the Attorney General. That was not on the record. It was just made in the spur of the moment, if I may put it that way.
Okay.
And that objection was to the effect that from second to sixth, the respondents. Now, when you look at the nature of the suit, it was the the Chief Justice as the plaintiff or applicant against Attorney General, and then the individual members of the committee. So in all, there were 6 respondents or defendants, depending on which one you're talking about. The Attorney General's argument was that from the members of the committee should not have been parties to the suit. And the reason was simple, that when he looks at the writ of summons and then the pleadings that were made, he made reference to a specific paragraph in which the Chief Justice had mentioned, or in that document which was filed for the Chief Justice, said that the person who will be affected will be the Attorney General. That is just the first respondent. And he says to that, to the extent that it was the only person that will be affected, it meant that the other 5 people are not proper parties. So the court should take them out, so that it will just be the Chief Justice against the Attorney General. The former Attorney General, who is lawyer for the Chief Justice, argued that no, that cannot be the position of the law, and that the fact that that person, the other persons were not mentioned as being affected, was inadvertent. And that even beyond that, the law is that it's not just about the person being named, but that's even where claims have been made against certain individuals or reliefs have been sought against certain individuals, they ought to be parties in the suit. So he pointed out that there are as many as 6 reliefs that have been sought against the members of the committee. So to that extent, they ought to be proper parties in the suit. The ruling of the court was very simple, that yes, they agree with the former Attorney General, Godfred Yabo Adami, that indeed, since claims have been made against the members of the committee, they need to be proper parties in the suit. We crossed that hurdle. Okay. The next was when the Attorney General, I mean, when I say Attorney General, I mean the Attorney General's department. Okay. It was represented in court by the Deputy Attorney General.
Justice Ramside.
Justice Ramside. Now began to move the motion for that matter I discussed with you about the exclusion of the supplementary affidavit. I mean, that was successful because the court agreed with him that indeed the matters that were deposed to in that affidavit were actually matters that happened before the committee, and as such, they need not be put out in the public. I mean, the former Attorney General, Godfred Yabo Adami, argued that no, in his view, what amounts to proceedings is different from what was deposed to in that affidavit. So he tried to distinguish what is proceedings and the things that they were complaining of as not being part of proceedings, but that did not find favor with the court. So that's one succeeded because it was coming from the Attorney General. So that succeeded. We crossed that hurdle, and now moving to the substantive injunction. Okay. Business for today was the injunction, but a lot of things had to be done before. But even before that one, former Attorney General raises another legal objection, and that was to the effect that why is the Attorney General representing the members of the committee? Because in his view, the Attorney General is supposed to be the lawyer for governments government agencies and the like. But so these persons, it was viewed that they were sued in their personal capacity, individual capacities. Why will Attorney General represent them? So, I mean, at that point, the bench had to intervene to ask him a few questions. That's for the two justices, for instance, they were doing their business. President nominates them to come and be part of a committee, and in their work, they are sued. They ask, who does he expect to go and represent them? Because it is not part of it's not their doing that they found themselves there. So they tried to explain that they were performing a public function. So indeed, Godfrey Addo agreed that indeed it's a public function, but he was still persistent to push that point. I think they reached a consensus when the bench had asked him that he should just rest his legal objection and go ahead to prosecute his case. That is now to take on the argument for the interlocutory injunction. Okay. So that was where we then delve into the proper matter of the interlocutory injunction. Okay.
And in the next few minutes also, we'll be picking the thoughts of the former director of the Ghana School of Law, Kweku Asare, who has also been following this entire episode about the Chief Justice very closely, right from the very day the story started or unfolded. So we'll get his thoughts on it. But Dennis.
Yes, now to the substantive matter, yes, which was the interlocutory injunction application.
We have the thoughts of Godfrey Addo, who is lawyer for the Chief Justice. We'll play that, which is a reaction to how things, or his thoughts on how the court decision went. So we'll come to that subsequently. You tell us how things proceeded when it came to the substantive issue.
Well, so he started off by setting out the issues that he wanted to argue before the court. The key one being the fact that there's actually a serious matter to be tried. That is actually a requirement if you want an injunction application to be granted. And that is from the point where he makes the case that as they speak, the Chief Justice has not still been given a copy of the determination of the prima facie case that has been made against her, for which a committee was set up, and then the suspension and all the proceedings ongoing. And he thinks that for a Chief Justice to be subjected to that kind of process without the benefit of having a copy, it undermines her fundamental human rights, which are enshrined in the Constitution. So basically, he advanced that argument that in the absence of that, what it essentially means is that the process is not right, for which an injunction must lie. He argues that this is not just a mere procedural requirement, as has been argued by the Attorney General, but that it's a constitutional requirement, for which the breach of it's a serious thing. He also went on to argue the basis why Justice Poamang and then Justice Seidu should not be part of the committee. He argues that because Justice Poamang had, in other cases, giving judgments that went in the favor of one of the petitioners, Daniel Ofori, he should not be part of it. It was that point that the bench intervened again to say that they, as justices, they sit on all manner of cases. Is he making the argument that if they sat on a certain case and then there's a petition and they are nominated to be on a committee, they should not be a part of it? So even the president, Justice Paul Bafuboni, said that that case in question, he was a part of it. Justice Yoni Kolendi was part of it. So is he saying that on the bench, they too don't qualify? Then Attorney General said, yes, in the circumstances, they don't qualify to be on that committee from where he's coming from.
Primarily because in the past, they've sat on a case that one of the petitioners brought before them.
Yes, but you see, the substantive argument of Godfrey Addo was that it's not just about sitting on a case, but that's one of the cases, it's actually the reason for part of the things that were brought before the president in the petitions. Yes, it's actually a judgment which is a reason for the petition. So that's why he was seeking that, because Justice Poamang was a part of it and he gave a favorable judgment to the petitioner, he should not be on it. In the case of Justice Seidu, the argument has been the same. I mean, we've been here before. And it was the same Godfrey Addo who made that argument, but it did not lie. I think he came on very forcefully again. That's, the initial panel that was put together to hear the very first case of Vincent Asafua. Justice Seidu was part of it. Before it could be heard, Justice Seidu was nominated to be on the committee. But they had not had the opportunity of hearing them because they had adjourned the case twice. So his argument is that because he had been on that committee, that panel from the right go, he should not have been part of the committee. They explained to him that this is a matter that we have decided on already. And the fact will bear them out. That he was even there at the first time they came, there was no sitting. The second time, there was no sitting. And the panel was reconstituted. So that, again, did not lie. So, the crux of the matter is that the arguments that the Attorney General made, yes, as forceful as they were, eventually, even though the court has not given it reasoning, it did not go his way. On the side of the Attorney General, so I meant the former Attorney General. Now, on the side of the Attorney General, his case was very simple. He started off by saying that the court has already given judgments in similar cases. At least this is the fifth one. So in 4 instances, the court has given judgments and it did not go that way, or the grant of an interlocutory injunction has not been. He also argues that even in the court's own ruling, a judgment of which we have a copy, he read portions of it to say where the court has specified instances where they can give injunctions and instances when they cannot. And they made it clear that when it has to do with these public interest matters, it will be very difficult. Justice Tanko intervened to make an explanation that if they are not careful, if they don't take a serious view of these interlocutory injunctions, they'll be there one day, and on the night before election, somebody can bring an injunction to injunct the election. Or on the night before the swearing in of the president, somebody will bring an injunction. And that was why they made a distinction as to how public interest injunctions should be granted and how private interest injunctions should be granted. On the totality of it, they listened to both counsel argue together with their all the documents that they filed. They went back into chambers, returned with a verdict, and it was a 5-0 decision in favor of the Attorney General. That means that the application for an interlocutory injunction has been dismissed. It is also instructive to add that even while counsel were making their arguments, the court was cautioning them not to go into a substantive matter because, an interlocutory injunction is just an interim application. There's usually a substantive matter to be decided. So the court said, no, you hold your horses. When we get there, we'll look into those matters. But as it stands now, this is the 5th interlocutory injunction that has been refused by the court. One of them was struck out for want of prosecution because the person never showed up. But for all the 4 that have been prosecuted, one was 3-2 dismissed. There was 4-1 dismissed, 4-1 dismissed, and now this is 5-0 dismissed.
Great. What options are available to Madam Justice Torkonoo, which means that do we know when now the committee set up by the president can sit?
Well, the committee has never been restrained to sit. The committee has always been sitting. And in fact, it's part of the reasons that she has brought this particular application to suspend. So if she has succeeded, it means that the committee would have suspended. Okay. In fact, in that supplementary affidavit that has been excluded or struck out, she made depositions to the fact that she appeared before the committee to bring to the attention of the committee that there was a pending matter in court, that the committee adjourned, and the following day they started sitting again. And that was when she complained about his searches and all that. So that is to establish the fact that the committee has already been sitting. Okay. The announcement we have is that they are sitting thrice a week. So if nothing has changed, the assumption is that they are still sitting thrice a week. We are unaware of anything that has come to order them to stop or that has impeded their work. Okay. So the assumption is that work is still ongoing. And
as far as we know, Madam Torkonoo is expected to appear before them when they require her
precisely
presence.
So. Unfortunately, the committee does not tell the public, or that announcement does not tell the public when they sit, except to say they sit thrice a week. So you can't tell whether it's Monday, Tuesday, Wednesday, or Monday, Tuesday. Yes. Okay. So
that's where we are at the moment.
Exactly.
Okay, thank you very much, Dennis Pwaberi Wedam Esquire, who interestingly was in court today to hear the specifics of the arguments for and against what was going on. And as you have heard, the judges have come up with a 5-0 decision, which was to dismiss the application of the suspended Chief Justice. So we will wait to see what the next few days hold, and also subsequently keep you in the time of when this committee set up by the president is expected to conclude their work and bring their findings. Meanwhile, right after the development, the court proceedings, the lawyer for the Chief Justice in the person of Godfred Yeboah Dame, who himself was a former Attorney General, has been speaking. He spoke to the media, or addressed the media moments after the court's decision. Let's listen to what he's been saying.
As a former Attorney General, to ask your opinion as a lawyer for Madam Torkonoo, what would you say to that?
Due process, rule of law, constitutionalism must prevail in Ghana. That is what we see. We did not, on account of people putting pressure on the CJ to resign or whatever, that we will take a decision. The most important thing is that there must be an upholding of the rule of law in Ghana. And we will continue to assert our rights. So the proper thing must be done. As far as I'm concerned, the proper thing must be done. And since the Chief Justice, she's been in office, she's been a judicial office holder for more than 25 years or so. She's been at the bar for almost 40 years. She knows what is due process. She knows what is constitutional rights. And I think that's what she's asking for. And how can it be correct that a judge who sat on two matters, of which she also sat, be called as witness in a petition against her, and that same judge be made the chairman of the committee that is supposed to inquire into the petitions against the Chief Justice? Clearly, it's untenable. It's only in this country that I don't know. And the question is, what account can she be singled out for removal from office when indeed she did not sit even alone? She sat as part of the panel. One of the judges' father is being made for witness. That's all. That's my recommendation.
And you heard the voice of Godfred Yeboah Dame, who is the former Attorney General and currently representing Madam Justice Torkonoo, the Chief Justice, who has currently been suspended. And it means that the 5-member committee, or the committee set up by the president to look into the prima facie case that has been established against the Chief Justice, can continue their sitting. And like we indicated, we will bring you updates when we do get them. We'll try and get the thoughts of a private legal practitioner who has actually shared a strong thought on the decision of Madam Gertrude Torkonoo to take on the state, or at least fight her way through this particular issue. When we are able to connect with our guest or our resource person, we'll put that conversation out for you to also follow the proceedings. So let's now engage the former director of the Ghana School of Law, Mr. Kweku Annan. Mr. Asare, good evening. Thank you for joining us on 3FM.
Good evening.
I'm sure you followed today's proceeding as well, and you earlier spoke to us and gave a position, which was that you said the Chief Justice was shooting herself in the foot by deciding to take the legal action in this matter. What are your thoughts following the fact that they have now dismissed her application and in a 5-0 decision?
Well, it just vindicates me. I think that those advising the Honorable Lord or Lady Chief Justice are not advising her properly. I'm saddened that up to now, I haven't heard any member of the Judicial Council express a worrying concern over, the ongoing affair. That's completely abandoned. She now has to go to court with her husband. So where is the protection? And then secondly, things that she shouldn't do. So all her moves, have not been in the right direction. So strategically, it's been faltering, from one application, to another application. And I think she herself, has expressed through her lawyer, Godfred Dame, this whole saga must come to an end. There are only, 2 ways. One of 2 ways. Either they allow the process, to terminate successfully, and then we know the verdict, or they appeal to the president to lift the suspension. As far as halting the process is concerned, I doubt very much whether once the president has set it in motion, he can reverse it. But he may decide, to lift the suspension. But if the suspension is lifted, that does not mean that the committee's work is terminated. So it is up to them to decide they have been put, or they put themselves in the election. My advice is that they should allow the process, to come to a successful end, in order for a verdict to be known.
That's an interesting point you raise about the fact that maybe the president should consider suspending the suspension or lifting the suspension. That would give her full access again as the Chief Justice, wouldn't it? And could she not, which probably was the reason why the president must have asked that she go on suspension or step aside, could she not, if she is in office, influence judicial processes in terms of probably empaneling, etc.?
I'm not saying the suspension should be lifted. I'm saying that it is either that she appeals to the president to lift the suspension while the probe continues. Lifting the suspension doesn't mean she can go back to work. Right. She can still remain at home and allow she has not been interdicted. Or that she allows the process that has been set in motion to come to a complete end. That's all.
Okay.
It's either one of the two approaches, not both.
Okay. You also made the point that it's likely that her advisors are not giving her the type of advice that would put her in the right line. Yeah, but she, from her affidavit that we have.
How do you advise the Chief Justice to go to court, the Chief Justice to sue the president? How? And then at the end of the action, what may she do?
Yeah, but
the
counsel,
one who advised her to take the matter to court hasn't
helped her cause,
done any good at all. She shouldn't have sued.
Okay,
she's the head of the judiciary. And if you look at Article 123(4), so it says that the Chief Justice, subject to the Constitution, the Chief Justice, subject to the Constitution, is the head, of the judiciary. He's subject to the Constitution. And if the probe going on, how can the head of the institution of governance responsible, for upholding the rule of law, herself thwart the process that will help in upholding the rule of law? It's an affront to common sense. I don't buy that.
But there is an argument
she should rather be allowed, for the sake of transparency, allow this process to go on. It doesn't mean that at the end of it, the petition will succeed.
Right.
I find it difficult to read any such meaning into the process.
Yeah, but it could also be, Mr. Asare, sorry for
cutting
in,
but say now is that when I said she has shot herself wrongly in the foot, I meant every word of it. You see, by taking certain courses of action, she has made it now impossible, to return to her job. It's difficult now for her to go back. Even if she wins, if the petition fails, she'll find it difficult to go back to her job.
Mr. Asare, sorry for cutting in, but you have a strong position. Maybe it is her advisors. There is also the school of thought based on the affidavit we saw and the injunctions he was seeking. The content of the write-up clearly tells you that this is a woman who believes she's unjustifiably being treated and wants to run the full course, or at least take on the system to clear herself. Could that not be her personal decision, and maybe her advisors could not convince her otherwise?
I don't want to believe or subscribe to the idea that merely because she's a woman, I don't want the gender,
No. I'm not talking
all.
about her gender position. I'm talking about the fact that as Chief Justice, she believes that the petitions and everything that is playing out is targeted at her, and because of that, she wants to use the same legal process to fight it. So it is not that her advisors have not been able to convince her not to even try the system, but she is personally taking that decision and going the full throttle.
Well, she's entitled to her opinion. She's entitled to whatever approach, she elects, to pursue this matter. As a pursuer, she alone, and probably the husband may decide, not even Dompreh, she alone may decide, to reconsider her position. But my advice to her is that being the Chief Justice, with enormous privileges, she should be, going to court as a Chief Justice to test what? Is she testing the rule of law, or she's testing womanhood, or what? You see, when you go to court, like, it was described, in the media this morning, now she starts, she wash, sometimes she'll talk to the husband, and why would she, bring all this bad threat onto herself? That is what, I find a bit worrying. Right. And that is why I'm advising that, she should just allow the process, and then at the end of the day, she may invite and urge the president to, give her a dignified exit. Right. That's what I'm praying for, a dignified exit. Okay. She's our Chief Justice. She has not been, removed. It was only a recommendation of the committee the president had set up that in view of the likelihood, of going into the allegations, presence, in the office every now and then may likely interfere with the proceedings. So she must take some rest. That is all. Okay. She has not been accused of anything. Right. There is no verdict, saying that she's, culpable of wrongdoing. Right. She's still the Chief Justice, with respect. Now the committee must, concede that she is the Chief Justice. Absolutely. And accord her all the respect due her. That's all.
Thank you so much. Always a pleasure hearing your legal thoughts on these issues. Thank you so much. Kweku Asare is the former director of the Ghana School of Law and shared some really interesting positions on this particular development.
No matter how many noises are made, the law is the law. No matter how many noises are made, the law is the law.
Yo, it for winning and someone about Yapono. So, Mikao says, so when you subscribe to channel idea, Bomodian say, over subscribe. Now, I like video to give us a thumbs up, Nafi, share my Fufrosuna, will you be here now? And somewhere Koso, Ewo Ghana memoir. Also, with me, otchere wondering if I hear some way who Ewo comment box in Mobati and Kabio in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.